morning. Welcome to the Subcommittee on Immigration and Border Security. It will come to order without objection. Chair is authorized to declare recesses at the committee at any time. We welcome everyone to today's hearing entitled New Orleans, How the Crescent City Became a Sanctuary City. I will recognize myself for an opening statement, and then my friend from California. I will introduce the panelists en banc, and then recognize you individually for your opening statements. As close as I'll ever come to being a judge, but there we have it. Time and time again, our nation has witnessed the tragic consequences of this administration's failure to enforce immigration law. Witnessing these tragedies is unsettling enough, but it pales in comparison to the grief and the anguish and the separation experienced by the families of those victimized. But today, we're not here merely to discuss the failure to enforce the law. It's even more disconcerting than that. We're here today because the Department of Justice, the entity that is supposed to be the chief enforcer of the law, is aiding and abetting local governments in the failure to enforce the law. Once again, the temptation to make a political point has transcended the obligation to take care that the law be faithfully executed. Under current policy, the New Orleans Police Department prevents its officers and employees from communicating with U.S. Immigration and Customs Enforcement regarding the immigration status of an arrestee. In May of 2010, New Orleans Mayor Mitchell Andrews sent a letter to then Attorney General Holder requesting DOJ, quote, transform the New Orleans Police Department, close quote. Based on the Department of Justice report, current Labor Secretary, then Civil Rights Division head, Thomas Perez, filed a lawsuit against the City of New Orleans and the Police Department, alleging various civil rights violations. On the basis of that lawsuit, the parties entered into a consent decree in 2012, which was approved by a federal court in 2013. This consent decree stated the New Orleans Police Department officers, quote, shall not take law enforcement action on the basis of actual or perceived immigration status, including the initiation of stops or other field contacts. And let me read the salient part of that again. Police officers shall not take law enforcement action on the basis of actual immigration status. And on February 28, 2016, New Orleans Police Department issued a written policy entitled Immigration Status, which, number one, prohibits officers from inquiring about an individual's immigration status. Number two, prohibits officers from assisting or supporting ICE's immigration enforcement. And number three, mandates any ICE request for support or assistance be declined. The New Orleans Police Department policy was not only vetted, but, quote, enthusiastically approved and supported by DOJ's Civil Rights Division. It was also reviewed and approved by DHS. The Department of Justice and Department of Homeland Security enthusiastically approve and support the failure of law enforcement to take note of federal immigration laws. In addition to being mind-numbingly antithetical to the faithful execution of the law, which is among the primary responsibilities of the executive branch, this New Orleans policy statement appears to violate Section 8 U.S.C. Code 1373, which provides no person or agency may prohibit or restrict federal, state, or local agency from sending, requesting, receiving, or exchanging information with ICE regarding unlawfully present aliens. On May 28th of this year, Chairman Goodlatte sent a letter to now Attorney General Lynch demanding that she explain DOJ's role in initiating litigation against the City of New Orleans and the resulting consent decree, and provide the legal justification for approving the sanctuary policies enacted by the police department. On May 31st of this year, DOJ Inspector General Michael Horowitz issued a memo to the Assistant Attorney General for Justice Programs in response to a request to investigate allegations that over 140 state and local jurisdictions received DOJ grant funds and they may be in violation of federal law. Specifically, the Inspector General was requested to investigate allegations the 140 jurisdictions who are recipients of funding from the Department of Justice are in violation of Title 8 U.S.C. Section 1373. For those of you who may be struck by the duplicity of the chief federal law enforcement entity providing grant money to state and municipalities who specifically fail to assist in enforcement of federal law, you are not alone. The Inspector General found the laws and policies in several jurisdictions go beyond regulating responses to ICE detainers and also address in some way the sharing of information with federal immigration authorities. After specifically reviewing the language of the New Orleans Police Department policy, and the Inspector General found, and I quote, "In our view, subsection A of the policy would not serve as a, quote, savings clause in addressing section 1373. Thus, unless the understanding of the police department's employees is that they are not prohibited or restricted from sharing immigration status information with ICE, the policy would be inconsistent with section 1373. On July 7th, DOJ's Office of Justice Programs determined section 1373 is, quote, an applicable federal law for purposes of determining statutory eligibility for relevant DOJ grant funding. Yet, despite the requirement of section 1373, DOJ awarded the Police Department New Orleans approximately $2 million in grants for fiscal year 2015. That very same day, July 7th, DOJ responded to Chairman Goodlatte's letter. And they outlined the policy, but they failed to explain how the New Orleans policies are lawful, which was a pretty important part of the letter in the first place. Then last Friday, September 23rd, just a few days after our hearing was announced, we received a letter from the Department of Justice claiming the revised policy the New Orleans Police Department had issued did comply with 1373. However, this revised policy makes no mention of Part B of Section 1373. And in addition, DOJ has not provided this committee with any indication of how officers will be trained to implement this revised policy or how seemingly minor changes to the text will ensure New Orleans will not be operating as a sanctuary city, which leads us to why we are here today. Not only does this place ICE agents and officers at greater risk when they're forced to arrest criminal aliens who are no longer in a secure jail facility, but instead in public places where they can more readily escape or access a weapon, but it also prevents officers from accomplishing their ultimate goal, which is public safety. We already know there are cities more interested in providing sanctuary for criminals than a safe haven for our very own citizens. We know there are cities who clamor for the federal government to assert itself into matters that are not inherently federal in nature, but refuse to assist federal law enforcement in matters that actually are inherently federal. And to put this in terms that almost anyone can understand, state and local law enforcement can be trusted to provide security for members of Congress, both here and in our home districts. They can be entrusted to enforce murder laws, child sex laws, kidnapping laws. They can participate in federal task forces on terrorism and narcotics trafficking. But God forbid they lift a finger to assist in the enforcement of federal immigration laws. But for the Department of Justice to go as far as seek a consent decree to actually inhibit the ability of the federal government to enforce federal law is stunning, even for a Department of Justice that has unfortunately become increasingly politicized. The consent decree can be interpreted to require New Orleans adopt policies that require its officers to actually violate federal law. Let me repeat that one more time. This administration's Department of Justice is actually requiring New Orleans police officers to break the law in an effort to further their political agenda. We have had multiple hearings on those that have been victimized by sanctuary cities. We've heard from their families. We're well aware of the tragic consequences. This is not a theoretical conversation in some law school conference room. This is real life with real victims and real grieving family members. Illegal immigration is not a victimless crime. Once you weaken the law, you weaken it forever. And once you put politics above the blind application of the law, it is done forever. And once you decide state and local law enforcement are good enough to protect us when we're back home in our districts, but not good enough to be trusted to assist in the execution of the law, good luck reversing that. that, I would recognize the gentlelady from California. Gentleman from Louisiana yields back. The chair will now recognize the gentleman from Iowa, Mr. King.
Thank you, Mr. Chairman. I thank the witnesses for your testimony here today, and I'd turn first to Attorney General Landry, and I'd like to pose a broader concept here, and then ask you to comment on that, and perhaps we'll go a little deeper. And that is that as I read federal law and immigration law, and as I understand it after these years on this committee, it envisions in its entirety essentially vacuuming up the illegal people in the United States and all of those whom are encountered by law enforcement. It anticipates their removal from the United States, and it requires that when at least federal law enforcement officers encounter someone who is unlawfully present in America, that they shall place them in removal proceedings. Would you agree so far with my characterization of federal law?
I do. I agree with that.
And then, so when I look at this statute, 1373, and I read through the details of 1373, shouldn't it be clear to anyone who intends to comply with the intent of federal law that they are to help facilitate rather than frustrate the intent of federal law?
I agree. You know, just placing the type of language that's been put in a consent decree dealing with immigration frustrates the law.
And I happen to have a little quote here from Mr. Richmond in a markup March 18th, 2015, which is about the time of the inception of this situation. He's concerned about the police department, the sheriff's office, who have a federal consent decree, and that they are complying with, this is a quote, they are complying with the federal consent decree. Now it will cause the city of New Orleans to lose valuable federal money in terms of DHS and FEMA funds, close quote. I think it's been known that there's been a clear violation here of at least the intent of the consent decree, or excuse me, the intent of 1373 by the consent decree and the underlying policy, which is a sanctuary city policy by my reading of it. Have you had any discussions or have you examined the legal language of this in such a way that that you're aware of any loopholes that are being exploited in this process? It seems to be a collaboration between DOJ and the city of New Orleans.
Well, again, it's concerning that the Department of Justice would go in and basically insert this type of language in a consent decree that had nothing to do with immigration or illegal immigration policies or enforcement of that by local law enforcement in the city. Again, I think that language frustrates the entire consent decree.
Would Fire Chief Spencer Chauvin be alive today if we'd enforced our immigration laws as intended by this Congress?
That is correct. I absolutely. In fact, you could make an argument that everyone who has been a victim or lost a loved one to someone who has been in this country illegally has lost that loved one simply because we failed to enforce existing law.
Would you disagree with a statement made by Donald Trump several weeks ago that there are thousands of Americans that are grieving today because of the loss of a family member or a loved one due to the failure to enforce immigration law in the United States?
I do. I agree with that.
And I'd say also reinforce that it's thousands. And we've had a difficulty in getting apples to apples in 2 GAO studies. Thank you, Attorney General Landry. And I turn to Inspector General Horowitz and just ask you just for clarification as I listen to your testimony and I read through your testimony. It doesn't come real clear to me as to your position on whether you believe that the sanctuary policy of New Orleans violates 1373.
We looked at the policy that pre-existed Friday and found they had a savings clause in their provision, meaning that if that employees could comply if required to do so by federal or state law. Our concern was how was that being interpreted and used, because Section 1373 doesn't require anything. It simply prevents state and local jurisdictions and federal jurisdictions from preventing employees from contacting or responding to ICE.
Does the policy prevent them from gathering or inquiring as to immigration status?
Other parts of the policy did address that.
And that seems to be the loophole that we've identified over some years here that's exploited by the local jurisdictions. As my clock ticks down, I'd like to then ask Ms. Gupta, as you spoke about this, is there any federal law or any statute that you're aware of that prohibits law enforcement from profiling and when they exercise their job?
Congressman, let me just make one thing clear, if I could, that there's nothing in the NOPD policy that prevents officers from requesting.
But my question is about, are you aware of any law or any statute that prohibits profiling and the enforcement of law?
Yes, there are. The Constitution obviously prevents the racial profiling and the exercise.
You mean to
of
say
law.
that if there happens to be a white-haired, light-skinned, blue-eyed person that has committed a crime and you're on the hunt for them, you can't say that?
Where there is a direct and articulated reason, reasonable suspicion, probable cause, these are the
Can you
standards
characterize
guide
the
us.
appearance of a suspect and the enforcement of the law?
It is
Gentleman's out of time, but you may answer.
Sure. Well, it is against the law to engage in discriminatory policing where
Mr. Chairman, I'd
policing
ask
decisions
unanimous
are made.
consent to press this witness until she answers my question. She's evasive in her responses.
Objection.
Well,
The witness has been asked and she has answered.
She's not answered.
She has answered the
I'd
question.
ask unanimous consent for an additional minute.
Mr. Chairman,
Well-
she has been asked and she has answered.
If the gentleman from Texas would yield, I will address the matter,
I'll
but
be happy
it's
to yield,
hard for me
sir.
to interrupt you and do so. Does the witness feel like she's answered the question as adequately as she's able to do so?
I do. I'm happy to finish the sentence or to yield.
No, you are welcome to finish the sentence.
Thank you. It is illegal and against the law to engage in discriminatory policing, to take policing decisions solely on the basis of one's race or other kind of protected characteristic, yes.
If the gentleman from Iowa has additional questions, we can entertain a second round.
I think the chairman and I would just point out that I don't believe I did get an answer to my specific question, but I think it's obvious to the members of the panel, and I would yield back.
Gentleman, Iowa, gentleman from Colorado, former United States Attorney, Mr. Buck.
Thank you, Mr. Chairman. Mr. Landry, have you ever prosecuted the case?
Sir,
Have you ever prosecuted a case?
a criminal case?
Yes.
Not until being an Attorney General.
Does your office prosecute cases?
We do.
Mr. Horowitz, you ever prosecute a case?
I did.
Ms. Gupta, have you ever prosecuted the case?
My office prosecutes cases, yes.
Okay. And Mr. Landry, who is your client?
The state of Louisiana?
The people of the state of Louisiana?
That's correct, yes, sir.
Mr. Horowitz, when you prosecuted cases, who was your client?
People of the United States?
And Ms. Gupta, when you prosecuted cases, who was your client?
People of the United States.
Okay. In your opening, Ms. Gupta, you say police officers on, this is the top of page 4 in your written submission, police officers cannot solve crimes and therefore cannot help victims prosecute criminals or help federal law enforcement deport violent criminals if victims and witnesses feel afraid to share information. Mr. Landry, why would a victim or witness feel afraid to share information?
Only because they would be afraid of the suspect.
Oh, okay. Well, how about if they are in this country illegally and they share information and they're asked about their status in this country? Would they feel afraid to share information perhaps for that reason? They could be deported or held if they were in the country illegally when they reported a case?
I believe if a person is victimized, they would report it regardless of that. But we've seen, look, as a former law enforcement officer, I've seen many communities, especially when you get into the poorer communities, that they're suspect of law enforcement altogether, regardless of their immigration status.
Okay, Mr. Horowitz, could someone feel afraid to report a crime because they, in fact, are committing a crime themselves?
It's been a while since I prosecuted a case, but you could certainly see that being a concern of the
Okay,
individual.
well, let's go further because it's been a while since I prosecuted the case also. So let's dig deep into the recess of our memory here. Mr. Horowitz, let me ask you something. Is it a allowable part of cross-examination to ask a victim or witness a question that would determine their motive for testifying or reporting a crime?
It is, and obviously depends on the judge's ruling as to the scope of it.
Okay, but your interpretation of the laws of the rules of evidence in a broad sense, that would be allowed to
Correct.
question about motive. How about veracity?
That would also be allowed, again, to the extent and scope that the judge allowed it.
Okay, and so if somebody were to report a crime and yet they had committed a crime or they had a motive, for example, a U visa, if they wanted to stay in the country, you understand what U visas are, it allows a prosecutor to apply to immigration authorities to allow someone to stay in this country if they are a victim or witness of a crime. It would be fair to inquire of that person whether they had committed a crime themselves by being in the country illegally in order to get a full picture about the prosecutorial merits of a case, would it not?
Presumably, but again, I think it would be, depending on the facts and circumstances, up to the judge ultimately.
Okay. So, Mr. Landry, let me ask you something. When the Department of Justice, the Civil Rights Division, decides that they are going to protect one group of individuals who are committing crimes in this country and make sure that we are not prosecuting another group of individuals, are they in fact choosing which type of criminal they want prosecuted in Louisiana, in New Orleans?
That's correct. It's exactly. We're choosing between what laws we'll follow and what laws we'll allow to be broken.
And why would someone do that politically? What is the political advantage of doing something like that?
You would have to ask them. I wouldn't engage in that type of activity.
No, you wouldn't, because it's unethical, isn't it?
That's correct.
If you believe that you are, in fact, not enforcing the laws, or if you enter into a consent decree and you are not representing your client, the people of the United States, the people who are being victimized, that would be unethical conduct, would it not?
It would be.
Mr. Horowitz, do you agree with that?
Depending on the facts and circumstances, yes.
I yield back.
Well, Mr. Butterworth, what's the penalty for crossing a border unlawfully?
I would defer to the Department of Justice on any.
Well, let's try it this way. Who has exclusive jurisdiction over immigration cases?
Again, it's outside of my lane, but I would say it's CBP or ICE.
So it'd be federal. It's exclusively federal.
Yes, sir.
Both, and they're really, unless you can think of something I can't think of, it's either crossing a border unlawfully or overstaying a visa would be about the only ways you could get in the country unlawfully. Only two ways I can think of. You either cross one of our territorial boundaries or you're invited in and you overstay your visa. And those are both exclusively federal. But I think you'll agree with me that almost all of our interactions in life are with state and local law enforcement. It's not an FBI agent who stops us for speeding. It's not an ATF agent who is working the bar scene. So if most of our citizen police encounters are state and local, and yet immigration is exclusively federal, how are the federal officers supposed to know about folks who are not here lawfully?
Sir, the Department of Homeland Security has the PEP program, which I am not at liberty to speak on. But I would say if Congress passed a law that commandeered every local police officer and wanted to pay for that, then I think we would welcome it.
When you say, well, commandeer is such a pejorative word, how about we just say cooperate? I mean, you don't commandeer people for your terrorism task forces, do you? You don't commandeer people for your narcotics task forces, do you? It's called cooperation. And yet you have a policy that says that New Orleans Police Department members shall not make inquiries into an individual's immigration status. What do you mean by inquiries?
Sir, if there's a criminal in New Orleans and an officer interacts with that person and there's a criminal warrant, that person.
See, I don't know what you mean by criminal. You mean if the person has, if there's probable cause to believe that an offense was committed, or if there's already an outstanding warrant?
If there's a state, federal, or local warrant or probable cause that an officer observes conduct that's criminal, they will arrest the person.
All right, and then they can inquire as to the person's status.
Our officers under this policy do not inquire about a person's immigration status.
They can or cannot?
Under this policy, they do not inquire about a person's immigration status.
Why not?
Because we believe that, one, this follows federal law, and two...
How are the federal law enforcement officers supposed to know who is here unlawfully if your officers don't inquire? They're not the ones that are interacting with them. They're not enforcing traffic laws. They don't respond to domestic violence calls. The FBI doesn't have jurisdiction over that. That would be your state and local officers. So how is that supposed to happen?
Sir, I think your concerns are with the broader system and not with this policy. In New Orleans, we arrest every criminal that we interact with. We bring them to the jail.
I love the way you phrase that. You arrest every criminal you interact with. They're only a criminal after they've had a jury trial, Mr. Butterworth. They're a suspect up until that point.
Correct.
Mr. Horowitz, if their original policy was okay, why did they revise it?
I don't know the answer to that question, Mr. Chairman. You'd have to ask the Civil Rights Division.
Well, you're a good lawyer, Mr. Horowitz. If the original contract was fine, you usually don't draft another one unless you just love paying lawyers. I mean, if your original indictment was okay, did you have a superseding indictment?
Generally not.
No, you don't. So if the original policy is fine, why did we get this brand new policy?
Well, obviously, our memorandum outlining the concerns we had about the provision that then existed may well have triggered the revisions.
I hate to be cynical, but I think you're right. Ms. Gupta, you said you were a prosecutor. There was a question I got way back in time that I never really had a good answer for. Whenever a family member who had lost a loved one to an act of violence to someone who was out on bond would ask me, why was that person out of jail? I never really had a good answer. I mean, you can cite the Constitution that you're really entitled to bond absent some circumstances, but that's kind of a hollow explanation. So what would the explanation be to those who have lost loved ones to violent crime for people who are here unlawfully and the federal government knows it?
There is, for somebody who's been accused of a violent crime, the NOPD is absolutely entitled and in its authority to prosecute to the law to the fullest. And there's nothing in this policy.
You're either missing my point inadvertently or you're missing my point intentionally. I realize you prosecute people after the homicide. I'm trying to figure out how to prevent the homicide. What is the explanation for why the person wasn't dealt with before the murder?
Well, let me just again make clear that the reason we undertook the policy was to ensure that NOPD could fight violent crime, could get the kind of critical information from victims and witnesses who need to share critical crime information with the NOPD in order to solve and prevent violent crime in that jurisdiction. Well, Ms.
Gupta, you and I both know that we rely on all sorts of witnesses, some of whom, frankly, expose themselves to criminal liability in the process of cooperating. So the notion that you have to give amnesty to people before they will cooperate with law enforcement has not been my experience. But Attorney General Landry, I'm out of time. You asked the question, how do you answer it when family members ask you, why was this person not dealt with before they committed the act of violence? I never really had a good answer to that one.
Unfortunately, I've had to answer that question in Louisiana here lately. And the best way I answer them is that our system in this country is broken.
With that, I would thank all the witnesses.
Can I ask unanimous consent?